Good evening, everybody. Welcome to this month's In Case You Missed It. I'm this month going to go over June's posts, but as usual, just a couple of webcast disclosures. So, just quickly, Ellison Legal has limited liability under a scheme which is approved by the Professional Standards legislation. And this webcast should not be taken as legal advice, and it is not intended to be given as legal advice. So if you do have any queries, please contact your legal practitioner so you can get that legal advice that is tailored to your specific situation. So now there you can see there is a different backdrop I'm with today. I do normally like to go a little bit outside, but didn't happen today. Like most of you, I am working from home, but I normally do work from home anyway, for flexibility purposes and for ease. I still have my office at Miranda, which is for my appointments and communication purposes, but most of the time I do work from my office. So welcome to my office for the first time. At home. Okay, so now going over June's posts, I'm just having a look at what we've done. We've had 4 different posts talking about deceased estate administration. Now, the first one we went over general administration. So basically, we're trying to explain what is a deceased estate administration and what is encompassed just by a general administration. So basically there might be a situation where a loved one has passed away and the assets that they hold is held jointly with somebody else. So somebody else's name is, say, on the same bank account as an account holder, not as say, for example, a supplementary card holder. We're talking about joint account holders. If it's property, it's held as joint tenants, not as tenants in common. I did have some information about that previously provided. Otherwise, please let me know if you need clarification on the difference between joint tenants and tenants in common. So this is if a deceased is holding assets as a joint tenant, or even if they're not, but the assets that they do have are, the word I'd probably use is minimal. So let's say it's money held in a bank account and it's, say, $10,000. Usually the banks will be okay to just release that without getting a court order, and I'll get into that a little bit later. But if it's a case where it's just minimal assets or jointly held or one of those scenarios, then you could possibly just go through general administration. In other words, no need to go to the court for probate, but there might be some reasons where you either need to or want to. So that's when we went into our other post. So the second post we spoke about was probate. So now, when I was just now talking about general administration, where we've got minimal assets or jointly held assets or something like that, you go through that general avenue. But the minute that a deceased holds assets on their own, and it's not minimal, it's quite significant. So say it's a significant sum of money in the bank account, and I'm really giving quite simplistic examples here, or it's property, it's real estate that they're holding on their own. You as executor, if you are the nominated executor, or appointed executor I should say, you'll be responsible to go get probate from the court. Now, probate is basically a document from the court saying you are the executor, you are entitled to basically manage that estate and and collect assets and distribute according to the will. If it's as simple as that. I'm not talking about estate litigation, I'm not talking about disputes, I'm just talking about straight up bring in the assets and distribute. So that's what getting the court order is. It's called probate, or a grant of probate. The third post we spoke about was letters of administration. Now, if there's no will, or if there's a will and there's no executor appointed validly, or no executor appointed, or they can't do it, or there's something where there's that slight intervention where the court needs to intervene a little bit more, then that's what we call letters of administration. So the grant of letters of administration is effectively the same as the grant of probate, but it's gone through that slightly different channel where the court needs to look at it and says, who is the correct person that should be appointed? Now, rather than in probate, the person nominated is called the executor. In letters of administration, there's a lot of tongue twists there. Letters of administration, the appointed person is called the administrator. But they're the two differences between probate and letters of administration, as bluntly as I can put it. But like I said, it can be done with a will, so there might be an existing will, but it's the executor's just not nominated properly, or they're not, they can't participate, or whatever it is. And I mean like no executor, not just one person. That's different. Or if there's just no will at all. If there's no will at all, the letters of administration goes down two different paths, whether the will is attached or whether it's not. But that's letters of administration. And the fourth post that I spoke about was ongoing administration. Now, most of the time, you're going to have a deceased estate. You call in you get your grant of probate, your grant of letters of administration, or if it's general administration. Well, if there's ongoing administration, you're going to need a court order. But with ongoing administration, you get your order from the court, you collect in the assets, and then you distribute according to the will. However, there might be some assets that are going to some beneficiaries that take the estate into ongoing administration. So, for example, this might be estate assets going to a child, a minor beneficiary, someone who's under 18, or in your will they might have been nominated as not benefiting under the will until, say, they turn 25 or 30 or whatever the choice made in that will. So if they haven't reached that age yet, as an example, there might be a testamentary trust. That's ongoing administration, so it's not yet complete. So we've gone past that initial administration stage, and now we're entering into the ongoing administration phase. So that's another part of it. So it's very, very basic information that has been provided. But we don't really want to overwhelm you too much. So that's what these videos are more about, is to explain in a little bit more detail what the posts are. But other than that, hopefully hopefully this has answered a couple of questions if you may have had any. Otherwise, feel free to contact me. My email is nicole@ellison.com.au. So Nicole is Nicole. There is no H. And Ellison is Nicole backwards, so it's ELOCIN. The phone number is 0291318500. So that's how you can contact me. Now that's June's posts. Next month in August, I'll be reviewing the posts of this month. And the posts of this month is going over just information about mortgages. And I will soon be releasing the information for August posts, and we'll swap back again to something in wills and estates. So look out for that in coming up in August. So until then, I will be here to answer any questions that you may have. So thank you very much for listening. Bye.